All yes. It is almost 4 o'clock, and I spent the afternoon at the food bank, and I went online to the Washington State Bar Association. Yeah, when I got to the library, because I noticed that no one has removed the protection order of the dissolution of marriage. Now we talked about fraud. And it looks to me that Judge Brent Basin is still practicing law. Now, I'm concerned that there's this reluctance to enforce the actual laws of the United States. So I looked for the Northwest Lawyer. Yes. It looks like one of those magazines that they give you for being an attorney. Yes. Mhm. Could you get me the subscriptions to the Northwest Lawyer, the online version, and then any of those that they mail? See, I was a little concerned thinking that non-attorneys were using the actual number of bar association attorneys. Yes. Now, I know that it would be a crime to kind of change the number a little bit. Instead of a 15112. Yes. You decided that it was a 15113. Now, for those that thought taking my cell phone so that you could be on me, yes, I did use the free Wi-Fi at the food bank, and I thought for sure that's what you were gonna do. Uh, Oh, you did, didn't you? You know, you should never attach yourself to my personal electronics. Yes. Now, just looking at the number of individuals that have been asked to leave the Bar Association, yeah, for approximately the last 400 years, no, 40 years. It's about 469 of them. Now, it looks like there are certain rules to be able to practice law in the state of Washington. Do you know what the rules of the state of Washington are to be able to practice? That there is no forgeries allowed of any court employee. Yes. That the actual petitioner has to be the petitioner. Mhm. And that the Superior Court judge has to be the Superior Court judge. And every individual that is in the Bar Association has to be the actual person themselves. You can't use a twin, a look-alike, somebody that didn't join the bar. Pooch. Now, for every attorney in the state of Washington, I need to know your malpractice again. It says online that you do have to identify whether or not that you do have insurance. But the WSBA does not require you to say the amounts or who your is, because I thought for sure you wanted me to sue you today. I thought for sure. Now, there's certain board policies to be able to suspend, yes, somebody from being able to practice law. There's lots of reasons that you can be asked to no longer practice law. Yes. But this board, the Washington State Bar Association's disciplinary board policies, yeah. Now, there's documents supporting stipulations. Yeah. The board reviews stipulations based only on documentation agreed upon by the parties. Now, I provided lots of documentation. I provided the documentation of violating the laws. Yes, false arrests, fraudulent mental health evaluations. And then there's the scope of the review, the ELC 11.12B. Prescribes the standard of review by which the disciplinary board reviews the decisions of the hearing officers. Could you get me each of the hearing officers in every state of the United States? Now, the board reviews findings of fact for substantial evidence. Yeah. The board reviews conclusions of law and recommendations de novo. Now, evidence not presented to the hearing officer or panel cannot be considered by the board. See, I've had a similar problem. I was arrested and no one admitted to the judge that I wasn't in Sequim, Washington. That meant the judge could not consider the actual evidence of my innocence. Now I'm going to sue you. Do you understand right now? Yeah, I'm thinking that this board that does the reviewing of the hearing officers, yes, I want all of them. Now, the intent of this rule was clearly to impose an appellate standard of review as used by the appellate courts. Now, let's say I motion the court for review of the various court cases that I've been involved in. Well, if there's no evidence, there's nothing for the appellate court to review. Right. So it must be that I'm schizophrenic and bipolar. Now, the board follows appellate case precedent in implementing the standard of review. The modern era of substantial evidence review of findings of fact begins with Thorndike's and Hesperian Art Church 54 WND 57343P2D. Now, Thorndike explains that a statute in place from 1893 to 1951, required the Supreme Court to review judicial findings de novo when the entire record was appealed. Yes. Now, let's say I want to appeal the whole record. Now, but the statute was repealed in 1951, returning Washington to the prior rule that the appellate court does not review factual findings de novo. The Thorndike opinion explains that henceforth appeals from judicial findings are governed by state law, RCW 4.44.60. The findings of the court upon the fact shall be deemed a verdict and may be set aside in the same manner and for the same reasons as far as applicable, and a new trial granted. Now, the court also quotes from early cases explaining the standard. Now, we had a non-jury trial judge, Roar, yes, where the pro se litigant, known as the petitioner, yes, did not comply with the requirements of the law of giving me notice of court hearing in the documentation. Now, I was spending a little time looking at some of these pro se litigants and how lawyers should work with them. Why don't you give me all of those lawyers in this state that think that having any knowledge of this kidnapping will not result in them going to prison? And if you hint, yes, at the touch, yes, of the sarcasm in my voice, you'd be surprised how absolutely serious I am about putting you in prison right now, right now.